Okay, good morning, class. Today we have your tests only, so make sure that you access the speed building. This is your 160 lit number 1, so words that come out. You have moped, United States, disavow. And this is 160 number 1 test lit for 5 minutes, okay? Let's say you bought a moped from a friend, paid him the $85 he asked for it, and brought it to your house for a trial run. That's when you found out the engine would not start. A moped with an engine that did not run might look fine in the garage, and someone might take a picture of you sitting on it, but it would not be very useful. It would probably be a sad disappointment if you had paid hard-earned money for it. There are, however, legal steps you might take if you were caught in this situation. These are provided for in laws related to contracts and sales and their special application to young people. These laws also regulate the various warranties provided by sellers and manufacturers. These laws would cover possible liability for injuries caused by defective products. When you buy a car, you enter into a sale that is a form of contract. A contract is a promise by one side to do something in consideration of some promise or action by another side. In this case, your friend agreed to sell the moped to you for your payment of $85. Contracts are made in many different types of transactions. In addition to sales, loans of money and sale of real property involve contracts. Some contracts apply to the services of persons or businesses. There are hundreds of laws concerning sales. Many of them are included in a book-like document that has been adopted in large part nearly everywhere in the United States. The general laws covering contracts are also numerous and complex. However, one principle that applies to young people is quite simple. If you are an infant or minor under the age of majority, you may disavow any contract that you make. To be able to do this means that you are not legally required to fulfill your contracts. This rule is designed to protect young people from unwise agreements that they might make due to their lack of experience or because other people tried to cheat them. In this case, you could simply return the moped and ask for your money back. If your friend refused, you would have the right to sue him for the return of the money. On the other hand, if your friend was also a minor, he would have the same right to disavow. He might demand that you return the cart because he decided that $85 was not a good price after all, or because he changed his mind about selling it. A minor may disavow the contract for any reason or for no reason at all, and he may do so even if he lied about his age in making the contract. However, he must do so within a reasonable amount of time. Of course, young people fulfill their contracts just like adults do because they wish to keep their promises and develop a reputation for doing so. The law does not prohibit minors from entering into most kinds of contracts. While they are free to disavow them as well, there are a few exceptions. In most areas, minors may be required to fulfill contracts for things furnished them by others who expect payment. Usually these things are items of food, shelter, or clothing, such as a winter coat. At some time, you might consider a cart to be necessary, but transportation does not fit into this category. Items that are related to your education may or may not be necessary. The age of majority differs from state to state. Many of these laws are being changed, and now most states have the same age of majority. In some states, special laws make it possible for minors to make contracts for loans and for insurance. Marriage is another form of contract, and in each state, the laws specify the age at which young people may marry without their parents' consent. In some states, once you are legally married, you are considered an adult for certain purposes and may be bound by your contracts. How about the adults who contract with minors? Let's say you bought that moped from an adult neighbor, a mechanic who built mopeds as a hobby. Could he disavow the contract because you are a minor? On this point, the law is clear. Your adult neighbor is free to contract with you, but he cannot disavow as you might do. In other words, if he wants to return the money and get his moped back, you do not have to give it to him. This may seem unfair, but the law exists to protect you. As an adult, he does not need this kind of protection. There are, however, a number of other general and then you have on your 160 lit number 2, Don Page, Mark Hill, Frank Page. This is going to be 160 lit number 2 for 5 minutes. The plaintiff, Don Page, brought this action against Mark Hill to recover money damages for the wrongful death of her husband, Frank Page. His death was the result of the injuries he sustained when the car that the defendant was driving collided with him and the rear of his pickup truck. At the time of the accident, the pickup truck was stalled on the highway. In a special verdict, the jury found that the decedent was 80% to blame for the accident. Accordingly, the trial court entered a judgment dismissing the case, and from that judgment, Don Page now appeals. The accident occurred during the hours of darkness on June 17. At the scene of the accident, the highway runs north and south. To the north, the highway is straight for about 1,800 feet. It then curves to the east. The decedent's pickup truck was in the right-hand lane facing south. In addition to the defendant, 2 of the witnesses in this accident gave testimony. The first witness was a young man. He was a passenger in the rear seat of an automobile that was coming from the north at a speed of about 40 miles per hour. He testified that the pickup truck was unlighted as his car approached it. His driver apparently did not see the stalled pickup truck until the automobile was almost upon it. At that time, his driver swerved to the left. The young man did not see the decedent standing near the pickup truck when his automobile went around it. The witness testified that he then looked back and noticed the headlights of the truck giving a dim light. His driver stopped the car approximately a block and a half south. They both got out and started walking back. The witness then saw the silhouette of an individual trying to push the truck. He also saw the headlights of the decedent's car as it completed the curve north of the accident scene. When the witness had walked about a block, he saw the defendant's car crash into the truck. He could not testify whether the dim headlights of the decedent's truck were still on at the time of the collision. There was evidence of skid marks made by the defendant's vehicle. They were in the west lane of the highway and they extended for 50 feet. The defendant's vehicle pushed the pickup truck off the highway and then came to rest about 200 feet south of the skid marks. The decedent was found lying in the center of the highway. He later died at the hospital as a result of his injuries. The defendant testified that he was driving south and that he was traveling approximately 50 miles per hour. He said the highway was dry and the visibility was good. He had his lights on low beam as he approached the scene of the accident. He testified that he had his headlights on low beam because he had met several vehicles coming north. When the last of those vehicles passed him, he saw the pickup truck in his lane. He was then about 90 feet from it. He immediately applied his brakes. He testified that he could see about 150 feet ahead with his headlights on low beam. However, he saw no lights on the rear of the pickup truck. He testified that he did not notice the decedent pushing the truck. The second witness to this accident was a woman who was driving north. She stated that she could see the defendant's headlights approximately a mile away. She said that both she and the defendant dimmed their lights. She did not see any object or headlights between them as they approached each other. When she was about 800 feet south of the accident scene, the lights on Mark Hill's car disappeared for a short time. The trial court submitted a special verdict to the jury. It inquired about the defendant's negligence as to speed, as to lookout, and as to control of his car. The jury found him careless only as to control and found that his negligence came to 20%. The verdict also asked about Frank Page's negligence as to leaving his truck standing on the road, as to having no lights on the rear of the truck, and as to display no warning flares or other warning devices. The jury found him careless in all respects except for leaving his truck standing on the road, and found that his negligence for causing the accident came to 80%. The appellant claims that Mark Hill was negligent as a matter of law with respect to speed. She says that he continued to drive 50 miles per hour even though his vision was... Okay, you all, that's it. Have a great day and type them up. See how you did.